This pretty much is heaven for me, you guys, so thank you for coming mostly. If it were an empty room, I wouldn't have this talk. Talking about fish in Vancouver is an incredibly fun thing for me. On the flip side, I've had a really bad stomach bug for the last few days, so if you see me dart for the door at any point, just take a break and I'll be right back. I've taken as much medication as I can, so hopefully that will not interfere with my delivery. Okay, well, most people think about law, they think about conflict, divorce, litigation. Another part of law, and maybe hopefully the more important part, is arranging relationships between people or between people and institutions, the government, other kinds of institutions, ahead of time. Trying to establish the ground rules for the relationship going forward. And sometimes that happens in an explicit fashion. In other words, we decide it's a good idea to have a law for these reasons. Other times it develops slowly and without much explicit thought. But property law fits in that category. What is property law? Well, if any of you own a home here, you're lucky, I guess. I come from South Carolina, where the average house costs about $220,000. It's a different world. But property law, right? Think of it this way: you have an exclusive right to the lot your house is on to use it. You can deny entry with very few exceptions, maybe a policeman chasing a criminal, but you can deny the public the right to come onto your property, right? Well, that's a choice we make. There are costs to doing that to the public, right? We have homeless people who might be able to otherwise pitch a tent in your backyard and so on. There's some cost to doing that, but we, as a society, our agreement is that the benefits to society of doing that, giving exclusive use to a single person, outweigh the cost. What are the benefits of exclusive use? Anyone? I'm going to ask questions while you guys. Any ideas?
Privacy.
Right. So we think it's important that people have privacy. Privacy makes good citizens. Privacy makes gives people space to operate and be creative and be individualistic. That's one of the justifications. Other ones would be, right, you can, I won't go too much into it, but certainly ownership of property, at least some people believe, some scholars going back to, say, Thomas Jefferson, or a diverse group of scholars, Milton Friedman I was going to mention, believe that owning property is essential to sort of healthy participation in the democracy, that you have a stake in what's going on. Also, and the earliest justification was that, look, I'm not going to invest in developing my property. I don't mean necessarily building a house or an apartment building, but say planting crops, if other people can then come on and take them without my permission, right? Why would I spend money on doing that? So we want to give people this incentive, right? Property owners an incentive to develop their property, because we do that by giving them the exclusive right to the profits. Okay, that's all to say, to set up this discussion of coastal property, and there are lots of different kinds. When I say coastal property or waterfront property, there are different categories under the English common law going back many centuries, but essentially we have sort of different rules, similar but different rules for what is called littoral property, which is property located bounding on an ocean or a lake. Lakes are thrown in with oceans. And riparian property, which is property that bounds on a river or stream. But for our purposes, if you hear me talk about waterfront property or coastal property, I'm just talking about any waterfront property. They share, littoral and riparian share a lot of characteristics. Okay. So this is a special type of property, clearly, right? It has a feature, this shared boundary, which I'll show you in a second, with the sea, that makes it different. And let's fast forward or zoom in here for a second. So, by the way, this is my own artwork, so I need to explain. I'm sure it's like obvious what's going on here. Okay, so I'm from the East Coast, so I always put the ocean on the right. That's the sea, okay, and that deep blue part is meant to be the part that's available for navigation, right? It's deep enough for boats to float. And that continues, that navigable channel, we call it, continues up through these tidal rivers or tidal creeks. This is brown, is just ordinary what we call upland, You can see I put in some sandy beach there, and that green is kind of coastal wetlands or marsh or something like that, tidal, intertidal area. Okay. So we'll zoom in. Here's a little spot you can see there. That's my land with some wetlands. Okay, so here's our terminology. I mentioned the channels and the inlet, the upland and the marsh. Okay, so going back to, say, 1300, it was pretty clear, it was the law in England, and it was understood by everyone that everything that was wet, and if we can use the term wet, it really was that vague at that time, everything that was wet was owned by the crown. And we still use that terminology here. We don't use it in the US, but we use it in England, right? Crown land. All of that stuff was public, and there were a couple of justifications for that. Number one, of course, the king or the queen, if it happened to be, especially at that time, liked to own as much. Always the argument was out there, unless you own it, I own it, right? The king was after title to as much stuff as possible. That's always good because you can give it away to people to get things, services and military duty and things like that. So we've got crown property or public property, I'll refer to it on this side. And then we've got private property. It's not always private, certainly the king could own that, but that property is subject to the private property realm. This stuff over here, with very few exceptions, and it changed with the Magna Carta, but very few exceptions, had to remain in public hands. The other justifications, by the way, which are important, were that, if you go back again to that period of time in England and actually up through the 1800s, most commerce, right, most movement of goods and people across space was done on the water. Lots of parts of England were not accessible by road, obviously with pre-railroad, etc. So these are commercial highways, you can think of them as, and so it was seen as important that no private party control that, right? Because that would give the private party a dominant position in controlling the entire economy. So that had to be in public hands. Of course, also these are seen as, especially in those days, as the buffer between, say, England and France, and they had to be at the control over the sovereign in order to protect the country in the event of war. That those spaces had to be available and open to the king. That's the justification for why that's public, and of course, this is just ordinary land. In the English system, originally, they just thought of land as land, but we know this is not ordinary land. It changes shape all the time, right? We have accretion, we have erosion, additions and subtractions from the land, and so on. So, over time, I mentioned setting up arrangements between parties, we began to have conflicts between mostly, right, landowning nobles and the crown along this boundary, okay, along that red boundary. And at the time, we don't need to get into it, I gave a talk on this recently at the law school, but that was just called a high water mark, or it was wet stuff and dry stuff. That's the way the courts, they use the word stuff, but that's how they dealt with it. Okay. So let's look at some of these conflicts and how they were resolved. Okay. So, three different types of things. First, in the earliest cases have to do, you can see my little, this is some accretion right here. Okay, so what that means is some sand has gradually built up on that side of the boundary, and that land is now dry. Who owns it? Well, technically, right, it's the same land that the king owned before, it's just not underwater anymore, so you could argue that the king should own it. On the other hand, right, the private landowners are arguing that it's contiguous to my property, and it allows me to maintain, right, the purpose of my property, this special kind of property, which is contact with the water, right? I bought waterfront property at a premium, perhaps, and if this goes to the crown, all of a sudden, right, in this space, my property no longer is special. It's just, right, it's landlocked. So, 1300s, and by the way, the courts always wanted to find in favor of this upland owner. It made more sense. It's very hard to prove how that happened and where the boundary was and is. So it's easier to just say whatever's dry is private. But the big obstacle was It's hard, this stuff is meant to be in public hands forever. So how do we get around that? Okay. So the courts came up with a rule that says if it happens slowly and imperceptibly so that no one could have seen it happening, we can't tell where it was before, then it goes to the private landowner, and really we're not taking anything from the king because the king can't prove where the line was before. Right. So that's called the rule of accretion, and that we still have that in Canada, we have in the US, lots of exceptions, but that's the general rule. So that would mean that if that happens slowly, the boundary, that red line, would move to the outside. I think I have a little picture of that. Okay. Two other types of conflict, and this is where we get to the meat of our talk today. So as time went by and as ships became bigger and more valuable in commerce, right, you've got to figure out a way to get goods from the navigable channel to land, right, and vice versa, if you want to have commerce. And what the king started doing, and still in England does this, is granting franchises, allowing private parties to build things like this. This is right, a pier or a dock to connect the navigable channel to land. You can park your boats out there and move goods back and forth. Or you can build facilities, if it's not that much of a stretch to the channel, you might be able to build things right here. And there were two objections that the private landowners had. Let's look at this one first. This was, when you do this, king, when you grant the right to parties to build, other parties to build stuff on this property, it's the same thing as the accretion right. You're cutting me off from the water. That's not okay. That's not consistent with my expectations when I purchased the property. I'm a waterfront owner, you're converting me to a regular owner, don't do that. And in fact, the English courts were somewhat receptive to that. They generally gave lots of leeway to the Crown to do what it wanted with its land, but it said the Crown it can do that in furtherance of public purposes. It can make that transfer if it really benefits the public, but it has to be careful not to cut off the upland owner completely unless it's purely for public purposes, the transfer. So a wharf would be for public purposes, a housing development would not be for public purposes. Also, the Crown was granting these, called a wharf permit to build on Crown land. And it creates a really awkward situation, right? Because this party that owns this right needs this party, right, to get the stuff from here to the road. And obviously, this party is not going to want to extract some amount of rent. And so it creates essentially, the franchise creates a way, sets up a negotiation between these two parties where you're asking the upland owner to share essentially some percentage of the value of the land with this franchisee. Okay. All right. That wharf conflict, the sort of who gets the benefit, who gets the sort of per capita tax on or tariff on every box that comes ashore, that was never resolved in England and was left in this form. So we had essentially the Crown. I'll show you a picture in a minute. The Crown really taking responsibility for developing wharves. Some situations of private franchises, but mostly public projects. A couple things. I'm not sure of any of these because none of them are recorded, but the states in the the colonies, the colonial governments, they changed that rule. And they said, upland owner, you have the exclusive right to build a structure from your property to the navigable channel. You don't have title to the underlying land, but we as the state stepping into the shoes of the king, you always have permission to do it. Well, turns out there are exceptions to that. If it goes too far and you interfere with navigation, if you interfere too much with your neighbors, right, to do that, might be a problem. But we granted this presumptive right, okay, the presumptive right to build a wharf. Okay, so what is that transaction, right? I kind of described, I think, in the abstract of the talk, essentially what you're saying, it's a subsidy, right? It's free use of public land, land that does not belong to you. Right? Why are we doing that? Why are we allowing that free use to this upland owner? Well, because going back to the exclusivity feature of property, the idea is by giving away something that's valuable to the public, we're going to get something more valuable back. What is that? It's a way for merchants to move goods back and forth. Farmers, right? Price of corn is going to be higher if I can move it to bigger markets. It facilitates commerce, which has tremendous benefits across the entire economy. So in the US, we created something called the right to wharf out. And let me tell you something, it really worked. What it did was, right, it also, by the way, meant that we didn't need public investment in this kind of infrastructure. It was all private because there's a huge private benefit to doing it also, right, which is that per capita fee on every box that comes across the threshold. So, let me show you how it worked. Anybody know what that is? That's from 1609. We don't have satellites back then. So it's recreated. That is Manhattan. Yeah, that's Manhattan. There's a project trying to recreate the ecosystems of what Manhattan looked like in 1609. And New York, like Massachusetts, like every colonial government, had adopted this right to wharf out. And what they did in New York, they did something called a harbor line, and which actually made it even easier. You didn't have to apply. You only had to ask the government for permission to put a wharf in if it extended past a line, okay, a line that was drawn around. In other words, you have unlimited rights to build these private wharfs in this area. So that's 1609, and that's 1860, okay? So you can see just a tremendous, right, they all go right to the line, and those are private, this little writing here, I don't know if you can read it, but it's Charleston Steamship Company, different railroad companies. Everybody's competing, which is, by the way, also good for merchants, right? When you have different ways to, if it's only a single party, it makes it a little tougher on pricing. Lots of competition, lots of private investment, all of which has its benefit to the public. So, let me get to today and the fun part. By the way, I said I was going to show you this picture. That's a picture of the London docks. And although you did have some smaller, it's not in this picture, but you have some smaller, what are called river wharves further up. These were large franchised, government-organized projects, okay? So these large kind of quasi-governmental entities, you might call them. But you can see these are big, that's excavated out of the land there. They're not sticking out into the water. There are a few little places where they do. But these are all these are docks, and they were essentially ponds built with little slips for the boats to sit at. But it's a very different way of developing this infrastructure. Right? We like, in the US, we like this sort of, not me personally, but traditionally, right, our courts and our legislatures like this sort of hurly-burly, individualistic competition, right? Like it fits perfectly with that. Today, I think, we don't have a shortage of wharves and docks in the US. We've got, some of them are run by, like the large ports are run by usually quasi-government agencies. But the riverborne commerce, it's not something we need a lot of extra investment in. And what you see in the US is these landowners, so this is in South Carolina, that's the Atlantic Ocean. This, I believe, is called the Black River. Comes from inland down, it's going to go out around there to inlet at the north end of what's called Pawleys Island. And those are docks, those little things you see sticking from the house. And those are, that is the modern expression of the right to wharf out. Those landowners apply to the state for a wharf, okay, and the state says, well, you have a right, it's a property right. If we deny that to you, or we might be liable for taking your property without compensation, so we're going to let you do it, even though the right no longer satisfies, right? It doesn't provide any public benefit whatsoever. What's the public benefit of this 500-foot dock right here? I mean, it increases the value of the home, so that adds to your tax base. But other than that, right, it's just a one house. These are little party centers out here, where you get the satellite dish with Saturday college football. That's how they do it in South Carolina. But these are just, that's what it looks like throughout the entire estuary system. And you can see these estuaries are not in good shape, right? And we've got, right, some dredging that was done there at some point in time, also probably to bring boats in. There's degradation related to the shading effect of those docks on the marsh grass, that's Spartina. So they're negative effects, but we can't get rid of this right because of our Constitution prevents the government, at least the government thinks it's going to prevent taking this property without compensation, this property right to wharf out. So I, for a long time, been trying to figure out, okay, like, that's bad. I I really don't, I don't think that's the best use of public resources, public subsidy, to encourage that type of private investment. So what could we do to replace that, to offer a replacement for these landowners that would benefit the public, and would maybe provide a sort of a good defense against a case alleging, right, a case by one of these landowners alleging a taking of private property if we deny them, or if we give them something else, some compensation in terms of other rights. Okay. So here are some of the ideas, or some of the things I've been playing around with, and this is, I've been thinking about this project for a long time, but I'm still in the fairly early stages, and so I hope to get some feedback, and especially I need help actually from, you'll see, from some scientists and economists in the room. These are oyster landings in the Chesapeake Bay in Maryland. That's actually where I'm really from. And you can see here, this is basically advent of steam dredge. All right, and this is where we are today in terms of landing. It's not because they're tightly restricted, it's because there aren't any oysters. At one time, say mid-19th century, Jeremy Jackson and others have established that the populations were so vast in the Chesapeake Bay of oysters that they filtered the water about once a week. All the water in the bay was filtered weekly. Now it's about once a year. Okay, so that's a 50-fold decrease in the amount of filtration that's going on. So we have lots of eutrophication. We have all the typical problems that are associated with too much nutrient coming in and nothing to take it out. And so that's a problem, right? That's more of a problem in the Chesapeake Bay than a shortage of wharves. So is there something we could do, right? Is there a property right we could create? Legislature can create new property rights, courts can, in order to encourage private investment that would remedy the problem. Well, let's go back to our picture. Oh, and by the way, I did find, it was a good find the other day. This is someone's cartoon about the ecosystem services provided by oyster reefs, right? Storm surge, water filtration, habitat for juvenile fish, all kinds of valuable public things. So what you could do perhaps is tell a waterfront landowner in the right place, not on the ocean front usually, but in an estuary, if you go ahead and invest in building, recreating oyster reefs, you will have, and on state land adjacent to your property, you will have the exclusive right to harvest oysters from that property. You could say in a sustainable manner or however you want to do it. But the idea would be, wow, that's an incentive for that private landowner to spend money restoring something we care about, not building a wharf, and that's good for everybody. Now, there's some public costs, right? Lots of people would complain and say, I'm not a waterfront owner, and I want to be able to go in there and take oysters from that public property. How is that good for me? And the answer would be, look, they're not there now. The state's not going to put them back there. We don't have the money to do it. This is the only way, right, to restore these oysters, right? Regulation and these kinds of things can only take us so far in restoring, as you saw from the prior slide. Regulating the oyster industry hasn't really done much to bring them back. It takes, in this case, some physical intervention. So that's one example. And I call that, my technical term for it is not the right to wharf out, but it's the right to reef out. Okay. Try. Sand dunes, another example I kind of throw out there. Right? Sand dunes provide tremendous public benefits, not just to the homeowners directly behind them. Storm surge protection protects lots of homeowners behind those dunes, and in the big hurricanes, you'll see the dunes disappear, but they've taken a lot of energy out in the process, so they're protecting structures. In addition, if you don't care about protecting structures, you probably should, because at least in the U.S. everybody ends up paying for people's lost homes. You've got habitat for lots and lots of endangered and threatened species, birds, plovers, lots of migratory shorebirds, et cetera, in those dunes, and you can recreate that habitat. However, right, there's a problem. If the beach, the dry sand beach, is deemed to be public, what private property owner is going to invest, right? What's the incentive for me to build it when I could maybe try to get the government to do it? I might say, maybe the cost of building a dune exceeds its value in protecting only my property. But if we add on the value of protecting other properties, we add on the habitat value, all of a sudden it's a big number, we want that person to do it, but those are external benefits. So they're not going to undertake that transaction. Okay, so what you could do is you could say, well, if you build the dunes, we, the public, will give you the exclusive right to the dry beach behind. You can actually create, we see this, you can really see it here, like on the Hamptons after Sandy, built huge, hundreds of millions of dollars worth of dunes, and there's a space that they leave between the house and the dune that is effectively now private. Okay, it used to be public. That to me is compensation. In some ways, it's an incentive because lots of beachfront owners want some, even though they bought a house on the beach, they still think they want some privacy. What we don't want is people doing this. Okay? That doesn't benefit the public at all. That's just purely private property protection. It protects tax base, I guess. But that sort of seawall approach is back. So we could create some kind of right to dune. I don't know what the right word is, but we could tell people they're entitled to build a dune, and in return they're going to get an additional slice of property that's subject to their exclusive control. And we know how to build dunes. It's really easy. That's an old picture. That's from Cape Hatteras, North Carolina. Most of the humongous dunes there, they come and go, and up to 100 and some feet tall, were built during the, as part of the Work Project Administration, same thing that built a lot of our national park hotels and things. These are otherwise unemployed people who are planting lots of dune grass. Okay, finally, marsh restoration. I mentioned oysters, but there's also just restoring salt marsh. It's a tough thing to do. It's pretty expensive. After, for example, I was involved in post-BP recovery in the Gulf, a lot of this stuff, it's incredibly expensive to replace it because you've got to not just replant like we're doing with the dunes, but you actually have to figure out a way to keep that sediment up, right? The grasses need to be at the right elevation or else they're going to die. And so it could mean bringing in truckloads of gravel. It could mean changing the flow of streams in the area to leave sediment in the marsh so that it stays at the right elevation. So it can be expensive, but you can see it's pretty degraded in a lot of areas. And again, huge ecosystem services provided by these areas, high productivity, juvenile fish, storm surge, water filtration, all kinds of things, bird watching, habitat, everything. So what can we do to encourage adjacent landowners to invest in seagrass or salt marsh restoration? I'm not sure, in this case, what the private incentive would be. The one thing I've come up with, and it's sort of, it opens up maybe a different can of worms, is saying this. If you can prove, let's say this is where we need a scientist, if I can prove that restoring a half an acre of salt marsh will provide some amount of benefit to the flounder fishery, that's a big one off the coast, right? Because that's where the juvenile flounder are. Maybe I'm entitled to some quota share in that flounder fishery, right? It makes sense. It's an investment in the stock. It's physically disconnected. That's why it's a little different, right? The stock's way out there and the restoration's going on over here. But logically, it makes a lot of sense. And again, it's the kind of investment that we'd like to encourage as something that goes along with regulation in terms of protecting or enhancing flounder stocks. So anyway, so I'm playing around with a lot of ideas about how to come up with a better, what I call a 21st century wharf, right? Something that makes more sense for us. Now, it may turn out, I wrote down some questions here, and I'll just read these out. Here they are, really quickly. Then we can take your questions and talk about these. Some of the key questions, is it a good policy? Do we like turning over ownership or partial ownership of these public areas, right? That's what you're doing when you tell people they have an exclusive right to take oysters. Some people would be opposed to that, right? Turning this into private property. And when we subsidize it, we're going to have distributional effects, right? There's going to be benefits to the waterfront owner, but like I said, the poor waterman down the road is not going to be able to get in there anymore. Maybe that's not fair, even though overall there's a net benefit to the public. When we put things in property, this is another reason we might not want to do it. It makes it hard to get out of them in the future because of this compensation requirement. So you could, if you do it with a regulatory measure, you might be able to change it later, but if you call it a property interest, when the government comes back and says, "No, we think it doesn't work," you may have to pay people to get rid of it, or at least you'll have to litigate lots of cases. Let's see, I'll skip over some of these. This is the one that I think is interesting for science and economics, is can we quantify the terms of this transaction? How do we know if it's worth it to give away these private property interests to build a reef? Are the services that we're getting in exchange for that, dollar for dollar, worth what the public is giving up by losing access to that area? And that would go with all these examples. How much benefit is an extra half acre of salt marsh to a flounder fishery that spans a huge geographic area? I'm not sure. I think wharfs, I suppose maybe this will take care of itself, but with the right to wharf out, it would apply to any waterfront landowner within a jurisdiction. But some of this stuff, we might actually only want estuary restoration, let's say, in some parts of the estuary. So do we give the right to everybody, and with maybe some bad results, or do we have zones where we do it, and say within this, if you own property within this part of the estuary, you have this right, but other people don't? Kind of interesting question. Is there potential for abuse? I'm a lawyer, so I always think of how can this go wrong? There probably is a way, and that's what I have. So I'm really happy to answer your questions about any of this, from the legal part through this part, the sort of science economics part, or you have other ideas for these kinds of structures. I'd really love to hear those. Thank you, John.
The one thing that I'm curious if you thought about is just like the insane amount of boat traffic. So let's say someone reefed out their property, a lot of boaters are gonna be very mad. Like thousands of people going back and forth. If there's the one guy that made an oyster reef, whereas everywhere else is a clear channel. How have you thought about that?
Yeah, well, it's kind of the zone thing. You might say that's not an area that's appropriate for us to give people that right. We don't want more reefs there because the value of the navigation is more important to the public. That could be the case. I think that's the answer, is that some places you want it, some places you might not. One of the fun things about shellfish in general, shellfish farming, but also in this context, is your shellfish farmers become your #1 environmental advocates, because their crops get destroyed by things like that, by pollution, all kinds of things. And so, whereas these people currently probably care a lot about their aesthetics, they're not so concerned about the environmental quality. So, to the extent that you let people invest in that stuff, they're going to take action to protect it. So, I don't know how that would play out in that context, but yeah. You don't want to block off the intercoastal water.
I wonder what the definition of contiguous is, because you had a right to make a reef. How far away from your private property would you be allowed to do that? Can I go 10 kilometers away? No. Can I go?
Well, you're going to always be limited, and this goes through this question as well. With the wharfing, you couldn't go into the navigable channel because that was detrimental to the public navigation. But it's crazy. In most U.S. states, wharfing out up until the 1950s was defined as building I didn't mention this because it's just bizarre, but building right to wharf out includes building a structure to the navigable channel, dredging a channel, which we saw in that picture, to the navigable channel, or filling it in. You could actually take that entire marsh and just put dirt on it, and that was your property, because that was deemed to be worthless, completely worthless, and in fact it was very harmful because it wasn't dry land that we could use to put something on. So the question, I think you could do anything out to that navigable channel. Once you get to the other side of it, I don't think, but that would be the natural limit, I guess. But you could do a harbor line like they did in New York. You could say everybody can do it out to 20 yards, seaward of the mean high tide line or something like that.
I have a question about dealing with something that was previously thought to be worthless and now we realize is not. Because, hundreds of years ago, you couldn't build your dock so far as to interfere with navigation because that was understood to be bad for the public good. But the ecosystem services were not at that time understood to be important, but now they are. So a lot of the examples you've given are from these positive incentives. How can you incentivize landowners? And I feel kind of dirty for suggesting this, but what about punitive things where we say, well, the public good, we now understand that the marsh is doing this much, so you actually don't have the right to put your little party dock there because that does not balance out the loss of the public good.
Yeah, I mean, that's where I started on this thing. You know, first of all, each one of those docks, it's different estimates, but a private dock in South Carolina adds about $100,000 to $150,000 worth of value to the house. So people are not going to lay down for that. Okay. So what does that mean politically? When you've got not just a few people, and these are the wealthiest people in South Carolina too, by the way, so that makes it even harder politically. So you've got a political problem getting them out. The legal problem is, as I mentioned, two things. One is that if it's already built and you're already going to take it out, you're going to have a pretty strong kind of condemnation claim. And so, yes, the government could condemn them all and pay for all that removal, whether if you just said everybody has to take them out at their own expense tomorrow, it would be a huge, I'm not saying the state would lose in the very end because of the arguments that you made. It's not a good use of state land. And we haven't given away title to the land beneath that pier. We still own it. So we could say, you're out, but we have to pay, I think, in some way, lawyers or compensation.
What about in terms of climate change? I mean, most of these, certainly in South Carolina, a lot of this is built on former floodplains. And with climate change, you're seeing far more impacts, as we've seen with the hurricanes the last few years. Should there not be, it's your own fault for building on floodplains, and as a result, you have messed up the ecosystem, and you have to pay for it?
We actually do the opposite. We pay people to stay in their home. We give them free flood insurance, highly subsidized flood insurance, so they actually, we pay people to rebuild, and it's amazing. I mean, there's a huge psychological component to this where this is valuable property and people are not going to part with it. And when I say people, I mean people who are voting and funding the government and are in the government. They're not going to come back and say everybody has to take this out. In fact, I never forget when I first moved to South Carolina 15 years ago or something like that. We had a conference and I brought up this exact point. Look, at the very least, we should be charging people an annual fee to have a dock that we can use for environmental mitigation, right? Makes perfect sense. Doesn't sound too bad. We had this conference, it was a 3-day conference. That was a minor comment that I might have made and I'm obviously no one knows anything about me still, which is great. But my point is, I'm on the front page of the paper, University of South Carolina law professors suggest, annual fee for docks, right? It was the most controversial idea. It was horrible. I'm like, right, I should be executed. So it's not an easy political thing. And same with the houses. People build them without insurance. They don't even care. I don't know what, maybe they must be buying for cash because, the banks aren't going to be excited about that. But, you can see here, these are, right, so they're doing that because that's above the 100-year, flood line. So technically, that's not in the floodplain anymore, under our rules. Right? That's why they're elevated, because they're above flood.
I like these ideas a lot. It seems like all your suggestions, though, are for compensation, seem to be about compensation in kind. That you're...
Yes.
Yeah,
that's what I'm doing.
I wonder about how incentivizing that is for private landowners who mostly buy this property for recreation or leisure purposes. If just simple tax credits would be, a bigger incentive for these folks.
It depends, right? This kind of the question about how do we connect the value of what you're providing to what we're giving you. So, an oyster reef, I don't know how much it costs, I'll be honest, and this is part of the research. I don't know how much it costs to restore an acre of oyster reef, and I also don't know what the revenues are that will be generated. It could turn out that no one would ever do it. It's a bad investment. But if it's a good investment and people aren't doing it because they don't have the exclusive right to take those oysters, we want to get rid of that obstacle, right? I'm trying to come up, the reason the right to wharf out, in my mind, was so brilliant by the Massachusetts colonial legislature was the first group to come up with the idea in 1644. It's brilliant because no one has to lay out any money. There's no public money at all, right? You just say, we'll give you this right that really doesn't interfere with navigation, right? The public needs because they're out there. And you'd spend the money and we get all this great commerce benefit. So I'm trying to do it without money, is the
Yeah, I can see.
answer. But the economics are huge. You know, going back to the ITQ example, you know, restoring a certain, you know, if you gave somebody a big quota share, that's worth a lot of money, right? You could just turn around and sell it. So, but getting that ratio right is important. Also, by the way, if you start taking away quota from existing holders, that's also wouldn't be that popular. Yeah.
This is all based on US law, which is based on English law. Is there any sort of other examples in other Commonwealth countries that have similar, that you could look at and say, this has worked here, let's see if it'll work here?
No, I mean, not really. I mean, there are lots and lots have been written in the last 15 years about how to create working markets for ecosystem services. So where you might have, let's say, you have downstream water users who are benefiting, right? Benefiting from upstream, let's say upstream we've got farmers, and farmers can improve downstream water quality by putting in buffers, vegetative buffers along the streams to keep the nutrients out. But they don't do it ordinarily because they're not required to and because it costs money. So is there some way we could set it up so that the downstream person could pay for that service, right? That's the transaction that you want to happen because that water quality is more valuable than the cost of installing the buffers. So there's lots of work in that area trying to set up property rights and ecosystem services. I don't know of any really on the coast in the coastal scenario. And, you know, obviously Australia, Canada, New Zealand, all have similar background systems. But as far as I know, the U.S. is the only country that ever came up with this right to wharf out. In other words, you can still have what's called a right of pure access. These other riparian literal rights you have in here and other Commonwealth, former Commonwealth countries. Yep. Yeah, maybe.
So if they're given this right in the past, which was good for the times, but now we know that it creates effectively environmental damage, having that right, and I can understand that taking back the right politically would be difficult. Can you not try to, in the law or regulation, tether the right with responsibilities to try to offset the damage to the environment that the right to wharf out causes? I mean, so some kind of, that the landowner, they can keep their wharf, but then in order, if they're going to, then they have to pay the cost to restore or mitigate the harm that's being caused by their right to wharf out.
Yeah, I mean, that's kind of what I got in trouble for a long time ago, was suggesting that was a good idea, right? Having an annual fee or something for mitigation, right? By dock owners, right? They contribute to a fee that's used for restoring that marsh across the way or something like that. That offsets the damage a little bit. I just, you know, I think it's you can require, right? It's state property, so all that stuff can be heavily regulated and heavily fined and feed, but politically it's tough.
Because it's
I
the
guess
same as in fisheries, right? I mean, like the public right to fish originally was what was in place, and then now increasingly we're tacking on more responsibilities to people that want to fish, and so
Right.
we're taking away the public right to fish in some places
Yeah,
by requiring licenses and that you can't do it in harmful ways and whatnot. So I understand that politically it's challenging, but is there not any political will also to? I mean, isn't increasingly that in environmental law is trying to tack on responsibilities to the harm that's caused by various things like industry or private landowners?
Yeah, I mean, I think going forward, that would be viable, in other words, for the next dock applicant, but in terms of, applying it retroactively to people who already have docks, you have sort of maybe a fairness.
Yeah, but you're not taking away the right to have the work. So they already had that, but now you're saying, okay, but now things have changed and the environment is not in a good state, so.
Right. Yeah, I guess.
And you're contributing to that damage or the harm to the environment, so therefore,
Yeah.
no?
No, I think, it's all perfectly logical, it fits into the category of, getting a legislature to pass a new tax, essentially, is what that is, and that's just, so what I've been trying to come up with is a win-win kind of thing, right, where it's
Yeah.
like the wharves were. I don't know if the numbers would support that, but that's kind of what I want to look into.
It sounds like though that you might create new problems, like you were saying,
You could,
right? Like if you gave them access to a quota or something like that.
yeah.
So, yeah.
Right, what if someone invested in restoring marsh and you gave them, quota share, and then, a lot of these marshes, right, that's the hardest thing to do of all these, but building an oyster reef and building a dune is much easier than building a marsh. And so, what if it died in 5 years? I guess, do you lose your quota share? Do you have to fix it?
Yeah.
What if it wasn't your fault? Lots of questions that
Yeah, because
you might create lots of problems.
yeah, the solutions you're trying to come up with is a continuation of that privatization, right?
Yep.
And that's what's creating the problems. And so I understand for politically that's what you need to do, but maybe it just needs to be a sea change.
Yeah.
Somehow.
I don't know.
This is sort of related, but do you know of have you worked with anybody who's tried to figure out how much damage is caused by the wharf compared to the actual usage of the channel? Because I feel like if everyone was docking canoes there, I don't think it'd be as much damage as like a 40-foot,
Right.
like twin prop, 500 horsepower.
Right. No, I don't.
Because then you're getting to the tangly situation of like, whose boat is that? Where'd they come from? Should they pay for the damage? Should they be taxed? Something, I don't know.
I don't know. Part of it is also another way I think about it is these people who own this property on the waterfront, right? They're really important to us. They're the only people that have, right? They have a direct ability to directly affect negatively or positively that channel in a way that I can't as someone who owns land 300 miles the other direction. And so, in addition to encouraging good investments that create social benefits, it might also be good to develop sort of a private advocates for conservation, like as opposed to the regulatory kind of approach where, especially in a conservative state like mine, where you're going to have lots of pushback. In an area some of you may have read about, that's the Charleston Harbor Bridge. Further south, another hour or so, is something called the Ace Basin, which is a large, ACE stands for three, AC is three different rivers that run through there. Huge areas of land that are now under what's called conservation easement, right? So we basically, it's a property interest where you as a landowner say, from now on, perpetuity, forever, no one can develop this land, and I'm going to donate that restriction to a land trust who will then enforce it against if someone buys it from me and tries to develop it. So it's a purely private decision. I'm doing this because, now there is a tax subsidy for doing it, but no one's forcing you to do it. And what's happened is that community, believe me, is as conservative as you can get in terms of the type of people who are property owners there. But they are the most vocal spokespeople for conservation in that area, that you could ever find, because they bought into it. They're all part of it. My land is important for these birds or whatever it is. I think if you could develop that similar kind of ethic by getting people invested in restoration as opposed to exploitation, which is what a dock is, that it might have some good long-term benefits. I don't know that would happen. That's part of the private conservation.
Yeah, I guess like in the US you could always go with the angle of like people really like to protect their property. So I guess you could go from that angle.
Mm-hmm. Yeah, and look,
Yeah.
the three most popular things in South Carolina, as far as I can tell, I'm not a native, but would be beer, college football, and oyster roast. People love their oyster roast, and they all go together, by the way. It's like one big Saturday fiesta. So, you know, they like oysters, so they actually want more, and it'd be so, how cool would it be if you could have your, you know, party on the dock, but harvest your own oysters, right? You know, maybe people can get into that. I don't know.